This is 106.7, Wilmington's Big Talker, and my name is Paul Vallone. I'd like to welcome you to Guns, Politics, and Freedom, where each Sunday at 5 p.m., as part of the Sunday Night Political Power Block, we give you the ammunition to better defend your gun rights. In case you aren't familiar with me, I direct Grassroots North Carolina, or GRNC, since 1994, our state's most effective gun rights organization. As its director, I was involved in drafting and passing our original concealed handgun law, and since then, GRNC has gone on to engineer passage of concealed handgun reciprocity, our purchase permit bypass, castle doctrine and stand your ground, the expansion of concealed carry into state and municipal parks, restaurants, public assemblies, educational properties, and much more. Grassroots North Carolina is exactly what the name implies, a grassroots collection of people from all walks of life who share a common concern that our constitutionally guaranteed freedoms are being eroded. Check us out at grnc.org. That's grnc.org. Today we have the good fortune to have as our guest the foremost expert on the law of self-defense around the United States. Andrew Branca writes, speaks, and advises on self-defense law and self-defense cases around the country. His expertise has been cited by the Wall Street Journal, the Chicago Tribune, National Public Radio, numerous other media organizations, as well as private, state, and federal agencies. He's a Massachusetts lawyer, life benefactor member of the National Rifle Association, and a former adjunct instructor on the law of self-defense at Sig Sauer Academy. He regularly lectures and speaks throughout the country on how to protect yourself against both an attack and the legal machine thereafter. Most recently, Andrew has become the host and self-defense law expert on the Outdoor Channel's TV show, The Best Defense. Welcome, Andrew.
Very happy to be here, Paul.
Thank you very much for joining us. Now, I know there seems to be no end to the bad legal advice I get from the kind of people I guess my father, who was also an attorney, used to call jailhouse lawyers. Even now, in the age of modern forensics, I had an idiot recently give me the, if you shoot him outside, you better drag him inside idiocy. Tell us about some of the common misconceptions on using deadly force in self-defense.
Well, unfortunately, it's a case where it's not that people don't know much about self-defense law. It's that most of what they know is wrong. There are a lot of sources of information on self-defense law, but most of them are bad sources of information. I can tell you as an attorney, for example, 3 years in law school, we didn't spend 3 minutes talking about self-defense law. So just because someone's a lawyer doesn't mean they know this stuff. Ironically, police are taught more about use of force law at the police academy than lawyers are in law school. But most of what they're taught is not actually intended to protect the officer against criminal liability. It's intended to protect his department against civil liability from being sued. All these prominent Supreme Court cases on police use of force, Tennessee v. Gardner, for example, those are all civil cases, and the officer himself is not even a party to those cases. So it's a very biased view. Even most firearms instructors, they teach a CCW class, and typically they get to the legal portion, and they read the class, the statutes, the relevant self-defense statutes. But I would suggest to you that if you've only read the statutes and you haven't read the court decisions that interpret and apply those statutes, you don't really know what those statutes mean, because they don't mean what the legislature might have intended to mean. By themselves, statutes have no effect in the real world. They don't have effect until a judge interprets and applies that statute in a real case to real people. And that's where the rubber meets the road. That's where the law is actually defined. And I see too many people who've read the statutory language think they understand what the law is, but in fact they don't, because it's not unusual for a court to interpret and apply a statute in a way that seems contrary to the plain English reading of that statute. So I deal with cases on a regular basis where people come into my office and they're in legal trouble not because they used force out of malice or because they were bad actors, but simply because they were literally, in a technical sense, ignorant of what the rules were, and they violated them out of that ignorance.
Well, let's put it this way. I carry a gun, and now I'm scared. You talk a little bit about, actually, I guess you're painting a pretty grim picture, and some of your book does, too, on what can happen after a deadly force encounter. You talk a little bit about the criminal justice pipeline and So if I'm forced to use deadly force in self-defense and presuming I prevail, what exactly can I expect afterward?
Well, you have to assume the worst. We have to prepare ourselves for the worst. And I should mention, I carry a gun as well. I have my entire adult life. I'm certainly not trying to discourage people from being armed for defense of themselves and their family. When I wake up in the morning, my gun goes on. I wear it all day. When I go to bed, it goes back in the lockbox right next to me, so it's accessible in the event that I need it. But I think it's doing themselves a real disservice if they carry that gun around and they don't actually know what the legal boundaries are for its use. And frankly, there's no reason for that, because self-defense is not the law of self-defense. It's not complicated. There's only 5 elements to a self-defense claim, just like there's only 4 rules of gun safety. We don't tell people it's too complicated to learn gun safety, but people do need to make the effort to learn what the law actually is, as opposed to what they might have read on some, heaven forbid, internet gun forum someplace.
Heaven forbid.
Now, when I say people need to be prepared for the worst, the way I like to describe it is people need to understand, they need to recognize that the moment they go hands-on, the moment they're engaged in a physical conflict with somebody, they've immediately incurred 2 risks. They've incurred a greater than 0 risk of dying and a greater than 0 risk of going to jail for the rest of their lives. Those are possible outcomes. So we need to be prepared for that possibility. And by being prepared, I don't just mean in terms of physical training, but I mean in terms of mental preparedness and decision-making. I tell people it's possible you could do everything legally right. I could have the most innocent client come into my office that I've ever seen, and I know that if I put that person in front of a jury, there's a 10 to 20% chance they're going to get convicted, because juries are unpredictable. So I tell people you need to be prepared for the possibility that you could go to jail for 20 years. And then you need to think to yourself, under what circumstances would it still have been worth it to pull that trigger? And I think if people think about it in those terms, the number of circumstances in which they'd be willing to go to jail for a long period of time is relatively limited. To keep themselves alive, to keep their families alive, absolutely. To defend their property, to defend a stranger, I think those get to be more difficult questions. Now, I don't tell people where to draw those lines. That's a personal decision people have to make. But I want them to be aware when they're making those decisions what the stakes actually are.
Excellent points all. And you touched on this a little bit, but exactly what are the prerequisites for responding to a threat with deadly force?
Well, there's 5 elements to any self-defense claim, up to 5 elements, I should say. Those are innocence, imminence, proportionality, avoidance, and reasonableness. Essentially, they simply mean you can't have been the aggressor in the fight. The threat you're facing has to be about to happen right now, not some future threat or a past threat. You have to use no more force than necessary to solve the problem, and deadly force only if you're facing a deadly force threat. You need to, in a minority of states, there's an element of avoidance, meaning they have a legal duty to retreat. North Carolina, under most circumstances, does not impose such a legal duty. And then finally, everything you do, your perceptions, your decisions, your actions, have to be those of a reasonable person. So innocence, imminence, proportionality, avoidance, and reasonableness. There's only 5 of them. Unfortunately, for a claim of self-defense to be defeated at trial, a prosecutor needs to defeat only one of those because they're cumulative. They're all required. So if he can defeat one of them, your claim of self-defense simply disappears. It goes away. And people need to keep in mind, when you claim self-defense, what you're inherently saying is, yes, I did it. I shot that guy. He died as a result, but I did it with the legal justification of self-defense. You can't claim self-defense and simultaneously claim it wasn't you who fired the shot. That would be logically inconsistent. So when you claim self-defense, you're inherently conceding to the underlying criminal act, but claiming justification. Well, if you lose that justification of self-defense, all that's left of that statement is effectively a confession.
I see your point. An excellent point. And as a matter of fact, reasonableness, I heard this on a lot of internet forums from those who oppose stand your ground laws during the Zimmerman trial, that all I have to say is I felt afraid, and I can use the stand your ground defense. That sort of tortures the definition of reasonableness, does it not?
Yeah, they're only getting half the picture. Probably, in my opinion, they're deliberately only expressing half the picture.
I would agree with that.
Yeah, reasonableness has two components. One is a subjective belief. You need to have a good faith, genuine belief that you're facing some threat against which you need to defend yourself. That's what these people against Stand Your Ground are describing. But a subjective belief that you need to act is not by itself sufficient to meet the conditions of reasonableness. That subjective belief also has to be objectively reasonable.
Very good. Thank you, sir. We'll return in just a moment. You are listening to Wilmington's Big Talker, 106.7 WilmingtonBigTalker.com, and I am Paul Vallone, your host for Guns, Politics, and Freedom. In a moment, we'll take a short break, after which we will return with Andrew Branca and the law of self-defense. So please join us after the break, again for Guns, Politics, and Freedom. My name is Paul Vallone, and you are listening to Guns, Politics, and Freedom today on Wilmington's Big Talker, 106.7 WilmingtonBigTalker.com. Our guest today is self-defense legal expert Andrew Branca, and we are discussing the law of self-defense. Welcome back, Andrew.
Glad to be here, Paul.
So, lawyers often use the word perfect self-defense versus imperfect. What exactly do those terms mean?
Well, perfect self-defense, normal self-defense, as I mentioned earlier, consists of 5 elements. All 5 elements must be present for your claim of self-defense to be effective. Now, if your claim of self-defense is effective, what that means is you have 0 criminal liability or civil liability for that use of force. It's an absolute acquittal for any offense, any legal liability you may have faced. Imperfect self-defense is not really a legal defense in the sense that imperfect self-defense cannot achieve you an acquittal. What imperfect self-defense is it's a circumstance in which you don't have all the required elements of perfect self-defense. For example, a typical way to get to imperfect self-defense is you used force unreasonably, so you failed the element of reasonableness. Often what the courts will say is, well, we can't let you have self-defense. We can't give you an acquittal because, well, it wasn't self-defense. You're missing the element of reasonableness. But if that's the only defect in your claim of self-defense, what we will do is we'll mitigate what would have been a murder conviction to a manslaughter conviction. So instead of spending the rest of your life in jail, you'll spend 15 to 20 years in jail. I don't talk much about imperfect self-defense in my own teaching because, frankly, for people like us, good guy cases of self-defense, it's not a win. Going to jail for 15 or 20 years is not victory from my perspective. I want people to be able to win both the physical fight and the legal fight in absolute terms.
That's an excellent point, yes. And you're right. That would be sort of cold comfort. Yeah, I'm only going to jail for 15 years. You talk a little bit about the AOJ triad. What exactly does that mean?
The AOJ triad is a framework for being able to both evaluate if you're facing an imminent threat and to be able to communicate to other people, to your lawyer and your lawyer to a jury, why your perception of an imminent threat was a reasonable perception. Eminence being, of course, one of the required elements of a self-defense claim. You must have been defending yourself against a threat that's about to happen right now. For an example of a threat that's not imminent would be someone threatens to go home, get a gun, come back, and shoot you with it. When they come back with the gun, they're an imminent threat. But at the moment they make the verbal threat against you, they're not yet an imminent threat against which you would be entitled to use force in self-defense. A lot of people, unfortunately, get in trouble on their self-defense claim on the element of imminence because they use force too soon. They use force before the threat has actually become an imminent threat, and therefore their use of force was not lawful self-defense. AOJ is a useful way for being able to evaluate, has the threat become imminent? And the AOJ stands for ability, opportunity, and jeopardy. And essentially it means, does that other person have the ability to cause me harm? Opportunity is, do they have the opportunity to bring that ability to bear? And jeopardy is, are they conducting themselves in such a way that a reasonable person would believe they're about to bring that ability and opportunity to bear? When you have all 3, AOJ, you're facing an imminent threat against which you can use force in self-defense. But if any one of those is missing, however real and genuine that threat may eventually be, it's not yet an imminent threat.
Okay. And it's interesting because I've taken some federal law enforcement training. They talk about ability, opportunity, intent, which strikes me as being very, very similar to what you're teaching there.
It's the same concepts, just different words.
Yep, that's exactly the way. When I read it in your book, that's exactly the impression I got.
What is sometimes done is sometimes people are taught AOJ as if that were the entirety of self-defense law. It's not. It's only one of the five elements. What people who teach it in that way are essentially doing is they're presuming the other elements. They're presuming innocence. They're presuming avoidance. They're presuming reasonableness. But it's a mistake to think of AOJ as being all the conditions that must be met. It's only one of the five elements that must be met.
Okay. All righty. And so we've talked a little bit about the prerequisites for responding to a threat with deadly force. And you talked a little bit about it because you said about using deadly force to defend property or to defend others. And you correctly noted that is it worth a potential 20 years in jail? But technically speaking, am I allowed to use deadly force to defend property in North Carolina?
Well, we need to distinguish between what kind of property we're talking about. We should really put property into two different buckets, which I call least defensible housing. However real and genuine that threat may eventually be, it's not yet an imminent threat.
Okay. And it's interesting because I've taken some federal law enforcement training. They talk about ability, opportunity, intent, which strikes me as being very, very similar to what you're teaching there.
It's the same concepts, just different words.
Yep, that's exactly the way. When I read it in your book, that's exactly the impression I got.
What is sometimes done is sometimes people are taught AOJ as if that were the entirety of self-defense law. It's not. It's only one of the five elements. What people who teach it in that way are essentially doing is they're presuming the other elements. They're presuming innocence. They're presuming avoidance. They're presuming reasonableness. But it's a mistake to think of AOJ as being all the conditions that must be met. It's only one of the five elements that must be met.
Okay. All righty. And so we've talked a little bit about the prerequisites for responding to a threat with deadly force. And you talked a little bit about it because you said about using deadly force to defend property or to defend others. And you correctly noted that is it worth a potential 20 years in jail? But technically speaking, am I allowed to use deadly force to defend property in North Carolina?
Well, we need to distinguish between what kind of property we're talking about. We should really put property into two different buckets, which I call least defensible kind of property we're talking about. We should really put property into two different buckets, which I call least defensible.
My name is Paul Vallone, and you are listening to Guns, Politics, and Freedom today on Wilmington's Big Talker 106.7, wilmingtonbigtalker.com. Our guest today is legal self-defense expert Andrew Branca, and we are discussing the law of self-defense. Andrew, on the last segment, we ran out of time a little bit, and we were talking about use of deadly force to defend other people. And you correctly noted that in an active shooter scenario, when the police arrive, if you have used deadly force to stop the aggressor, then perhaps the first person they see with a gun is you. So
absolutely. And by the way, this happens to law enforcement, too. There was a shooting in Texas just a few months ago, a school shooting, and the call went out to all law enforcement in the area to come to the school. One U.S. Marshal got to the school before apparently the uniform cop showed up, and he saw a dude walking around with a gun, and he shot that guy. That guy turned out to be a Border Patrol agent who was also responding to the call of a school shooting. Now, if that's what happens with trained professional law enforcement in these events, we have to presume that we're not going to fare any better as civilians.
As a matter of fact, I know of one federal law enforcement training scenario. They were shooting with simunitions, and it was in a, shall we say, a sensitive area. I really won't discuss exactly where, a secured area. And suffice to say that when the cops showed up, the other good guys who were not in uniform got shot just about every time. So yeah, that's a big hazard. And as you correctly noted, you stand a significant risk using deadly force for other people in defense of other people that you don't know because you don't know the situation that's going on. And in fact, I can think of at least one case not long ago in Greensboro where the law enforcement officials shot the wrong guy. But the difference, of course, is they have civil and criminal immunity, providing they were not grossly negligent, and you as a civilian do not, correct?
Absolutely. We do not have that qualified immunity the police officers have in the course of their duties. And I have to say, from my own perspective, when it comes to the defense of others, when I became an adult, I got a gun, I got trained in how to use it, I became proficient, I learned what the laws are, and I prepared myself for what I consider a fundamental adult responsibility, which is to be able to protect myself and my family from criminal predators. That other person, they could have done that. And why is the fact that they didn't do that make them my responsibility? There's a lot to be said for being a good witness. We all have cameras on our phones now. We all can call the police, record what's going on, make the other person aware, the aggressor aware that we're a witness, and make that our role as opposed to using force. People have to keep in mind, the moment you point a gun at someone, you're committing the crime of aggravated assault that could put you in jail for 10 to 15 years if your claim of justification fails. That's the legal risk that you're taking by doing that. Heaven forbid you actually shoot and kill the person. You've committed the crime of murder unless your claim of self-defense justification or defense of others justification holds up. If it doesn't, you committed murder, and you're going to go to jail for 20 years for the rest of your life. Those are the stakes we're talking about.
In many cases, I see things, newspaper accounts, and I look at even cases where, fortunately, a grand jury failed to indict somebody, but I'm looking at it going, no, that was not a correct use of self-defense. I guess, and I haven't really followed it very closely, but I guess just recently, just yesterday, I believe, a woman was accosted and robbed in her motor vehicle, a pregnant woman. She tried chasing down the robber for a period of time, but because she was pregnant, she couldn't run, so she got in her car and ran him down.
I saw that in the news.
I take it you wouldn't approve of that use of deadly force.
No, I wouldn't, although I certainly get it. But I'm glad you brought that up, because one of the big problems I see in the self-defense community is people learning the law of self-defense from anecdotes, from stories they read in the media or see on the internet. What they need to understand is that in many cases, a person might use force in good faith, genuine belief they're acting in self-defense. In fact, they're not. They're breaking one or more of those elements required for legitimate self-defense. But the authorities choose to use their discretion not to prosecute, convict them, and send them to prison. Well, when people read these stories and they see someone used force and didn't get prosecuted, they conclude, well, that must have been a lawful use of force then. No, not necessarily at all. It could just be they got a lucky break. And that same prosecutor who decided not to prosecute that person, the very next day on the same facts, they could decide to prosecute you. So we can't learn the law from what we read in the papers. We have to learn the law from the actual sources of law, which is statutes and court decisions.
Here. And as a matter of fact, I remember a case, it was in Gastonia several years back, of a homeowner who discovered someone in their garage, the curtilage, technically speaking, I suppose that falls under castle doctrine by most interpretations, but then he shot the individual as the individual was fleeing, and that, of course, would not be a justifiable use of deadly force. However, for whatever reason, maybe because the grand jury was sufficiently incensed at the robber, they did not indict this guy. So that is a perfect example of what you are talking about, where just because he got off doesn't make it a justifiable use of self-defense.
Right. We have to be prepared for the worst case legally. Just like we carry a gun because we're prepared for the worst case physically, right? A deadly force threat against us. We can't merely prepare ourselves for what will happen legally if we get a lucky break, if someone uses their discretion in our favor. We have to be prepared for what a prosecutor can do to us if they choose to.
Now, on a different topic, back in 2011, Grassroots North Carolina was involved in drafting and passing House Bill 650, which we called, Castle Doctrine. And if you don't like that that law, by the way. Blame me, because I was heavily involved in drafting the thing. And I'll be perfectly honest, a lot of it was lifted wherever possible from Florida statutes. And, of course, it also included stand your ground provisions. What exactly does that statute do in terms of its so-called castle doctrine, which I understand you prefer not to use that word, but for lack of a better word, what does the castle doctrine provision do?
Well, essentially what it does is, as we talked about earlier, in those highly defensible types of property, your home, business, your occupied vehicle, it creates a legal presumption that you had a reasonable fear of an imminent danger of death or grave bodily injury, or North Carolina says serious bodily harm. It means the same thing, really. So what they're doing is they're effectively giving you most of the elements of a self-defense claim up front in the context of those highly defensible properties.
And as I recall it, that is in specifically if the perpetrator makes a forcible and unlawful entry into your home, your motor vehicle, or your workplace, correct?
Yes, there's a number of hoops that have to be jumped through. That is one of those conditions. And it's very important because some states don't require both. For example, I live in Colorado now. Here in Colorado, the person need only be unlawfully present. They don't need to have been forcibly entered the home. North Carolina does require both. It's one of the reasons I tell people that when you're home, for Pete's sake, keep your doors locked when you're home. Make that bad guy break something. Make him, if he's going to come in, make him forcibly enter. Don't just leave your garage door open where he can just waltz in without having to break anything. You also mentioned curtilage earlier. We need to be very careful about curtilage. This defense of dwelling statute certainly applies within the four walls of your home, but it becomes much more of a gray area the moment you step outside your home. The North Carolina courts have not provided any really concrete definition of what qualifies as curtilage. The general concept of curtilage is it's the area immediately around your home that's part of the normal day-to-day function of your home. But that's a very subjective call. There's appellate court decisions in North Carolina where they've essentially said the issue was whether someone's porch qualified as curtilage and therefore qualified as part of their castle. And the court said, well, maybe. It depends. If there's a porch that has furniture on it and you actually spend time out there and there's a table, yeah, then it's almost like your living room. That would qualify as curtilage. But your next door neighbor could have a very similar porch that he really doesn't use for anything. It's just a poured concrete slab, and that wouldn't qualify as curtilage. So basically it's going to be a judgment call that's made by the jury on a case-by-case basis.
Interesting. Okay. And we were told by legislative counsel at that point in time that such areas would be curtilage, but of course, legislative counsel isn't the guy calling the shots in a court of law. So I'll take your case law over his advice any day. All right. And there are provisions under which you cannot use a castle doctrine defense, if you will. And after we get back from a break, I'm going to talk a little bit about stand your ground. But when can you not avail yourself, very briefly, of castle doctrine?
Well, certainly if you were the initial aggressor yourself, then you're not going to qualify for these defensive dwellings. They're intended to allow an innocent person in their home, place of business, or vehicle to defend themselves against an act of aggression. They're not intended to allow you to become the aggressor in a conflict and use force against another person.
Okay. All right. And I'm going to have one more thing I want to touch on when we get back. But in the meantime, you are listening to Wilmington's Big Talker 106.7, WilmingtonBigTalker.com. And I am Paul Vallone, your host for Guns, Politics, and Freedom. In a moment, we will take a short break, after which we will return with Andrew Branca and the law of self-defense. So, again, please join us after this break for the next segment of Guns, Politics, and Freedom. My name is Paul Vallone, and you are listening to Guns, Politics, and Freedom today on Wilmington's Big Talker 106.7, WilmingtonBigTalker.com. Our guest today is self-defense legal expert Andrew Branca, and we are discussing the law of self-defense. Now, Andrew, we were in the middle of discussing castle doctrine the last time, and as I have expressed, the problem we were worried about when we drafted castle doctrine, that you might have some drug dealer on a multi-house gunfight try to avail himself of a castle doctrine defense. There are a couple of things that would prevent him from doing that. Are there not?
There's actually four. So first of all, these legal presumptions that are created for the benefit of the defender in his home or his place of business or his occupied vehicle are rebuttable legal presumptions. In other words, you start with the benefit of the presumption, but the prosecution does have the opportunity to try to disprove those presumptions to the jury. And if they do, then you lose the benefit of having had those presumptions to start. In addition, there's four conditions that exist in the statute that will deny you the legal presumption of reasonable fear of death or grave bodily harm that you would otherwise have had. One is you don't get the benefit if the person you're using force against is also a lawful resident of that home or the workplace or the vehicle. So if they're lawfully there, if it's their castle too, you don't get the benefit of the legal presumption.
Makes sense.
The other is kind of a what would appear as a kidnapping scenario where someone's trying to grab someone from the home. Well, that doesn't apply if the quote-unquote kidnapper actually has lawful custody of the person they're taking. So if it's a custody dispute situation, you're not going to get the benefit of the presumption. Also, if you're using the home, the workplace, or the vehicle to further a criminal enterprise, you won't get the benefit of the legal presumption. And finally, if the person against whom you use force is a law enforcement officer or someone in a similar capacity, you won't get the benefit of the presumption.
Well, thank you for expressing that, because I like to think that when we were involved in drafting this law, it was a fairly carefully crafted law that was designed to prevent abuse, and which, of course, would come back and bite everybody. Would you agree that North Carolina's Castle Doctrine law is pretty well crafted the way it is?
I certainly would.
Excellent. And speaking of laws that are, in some cases, unfairly maligned, let's talk about stand your ground. Now, during the George Zimmerman-Trayvon Martin case, everybody in all the left was screaming bloody murder about stand your ground laws, calling them license to kill, claiming that all I have to say is I was scared and I can shoot somebody. We could go on and on. Tell me a little bit about stand your ground. My understanding is that it didn't even apply in the Zimmerman case, and so tell us about that.
Well, the first thing we need to be clear on is the actual terminology and what we're talking about, because the phrase stand your ground is used very commonly in an overbroad way. Even lawyers in courts do this, so it's certainly forgivable, but it leads to confusion in discussing the legal concepts. Stand your ground literally simply means that you're being relieved of an otherwise existing duty to retreat before you can defend yourself. It takes that element of avoidance off the table. The other elements of self-defense are all still there. You still have to be the innocent person. You still have to have been facing an imminent threat. You still have to have used no more force than necessary, and your conduct still has to be that of a reasonable person. All that's done is they've removed the duty to retreat. Unfortunately, when Florida adopted that stand your ground, no duty to retreat position, it also at the same time adopted a completely separate statute that provided for self-defense immunity for people who used force in self-defense. These are two very distinct legal concepts. So we need to, when we're talking about a duty to retreat and that element of avoidance, it's stand your ground. When we're talking about self-defense immunity, it's simply self-defense immunity that we're talking about. Two very different legal concepts. Now, in the George Zimmerman case, it was not a stand your ground case because George Zimmerman never had an opportunity to retreat once the fight was on. So retreat was never an issue in that case. In terms of self-defense immunity, he could have applied for self-defense immunity. He didn't, and I know this from speaking with his counsel. They didn't do it because the politics around the event were so striking. They simply didn't believe that the judge would have the moral fortitude to grant them the self-defense immunity they were clearly entitled to.
I see. Okay. And you raise an interesting point because when I was involved in the many debates over the Zimmerman case, I pointed out to the leftists when they were screaming bloody murder about Zimmerman being acquitted, I said, well, if it's any help to you, the stand your ground law really didn't apply at all, so this really has no bearing. However, the civil immunity section does apply, and now he can't be sued. Just a thought. I'm dating liberals. Technically speaking, George Zimmerman has never bothered to obtain
his immunity. They've never gone to court and gotten that adjudication of immunity. They simply haven't bothered. Now, I can assure you, because the Zimmerman case was the cleanest self-defense suit I've ever seen brought to trial, I can assure you that if someone does decide to try to sue him, he simply will go to court, have a pretrial hearing, file a motion, and he'll get self-defense immunity like that, because it was nothing but an obvious case of self-defense.
I'm so glad you put that as the cleanest case that you have ever seen, because that's the way it struck me. And it's so sad that people can be destroyed. Even in this case, the man's life was destroyed, even though his use of deadly force was perfectly justifiable and saved his life. It's a very sad state of affairs.
The only reason he was prosecuted was because the prosecutor in that case needed to improve her prospects for re-election. That's the only reason.
Ouch. All righty then. Let's see here. We are getting toward the end. I want to talk a little bit about the services you offer to people. Now, I've already mentioned that your site is the lawofselfdefense.com, I believe. Is that right? Lawofselfdefense.com, right?
Lawofselfdefense.com. That's correct.
Now, I know that you've come to North Carolina a number of times and given seminars that I know were very well received, both basic and advanced level seminars. Tell us a little bit about what you do and what people can expect to learn from your seminars and why they should take them. After all, they've taken a concealed carry course, right?
Well, unfortunately, as I say, the concealed carry courses tend to focus on statutory language, which doesn't really give you a very contextual picture of what the law of self-defense actually is. Frankly, we generally recommend people kind of enter the law of self-defense area by first looking to our book, because it's the cheapest way to obtain solid information on this area of the law. And that could be obtained at our website, just lawofselfdefense.com/book. Or it's available on Amazon. The Kindle version's only $9.99, so it's a very inexpensive way to get yourself educated on what the law actually is. And that book covers all 50 states. As you mentioned, we also do live classes all over the country, typically twice a year in North Carolina, and those classes are specific to whatever state we're in. So we spend the entire day on our Level 1 class, typically on a Saturday, going over these 5 elements of a self-defense claim and illustrating them with North Carolina statutes, court decisions, and jury instructions.
So these are state-specific. We should note that, right? You go to multiple states, and each one is tailored for the state statutes where you are teaching the seminar.
Absolutely. And then typically on the following Sunday, the next day, we'll also have a Level 2 class where we'll take the 10 or 15 most important appellate court decisions on self-defense, defense of others, and defense of properties, and dive into those decisions in detail. So we look at the parties involved. We looked at what happened at the trial level. We looked at the grounds for appeal. We looked at the legal analysis done by the appellate courts and the conclusions they come to, the decisions they write. Because as I mentioned when we started, it's in those appellate court decisions where the rubber meets the road, where the law is actually defined. Because a statute doesn't mean what the legislature might have intended it to mean. It means what the courts, particularly the appellate courts, say that statute means when it's applied to real people in a real case.
Oh, okay, an excellent point. And also, as I recall, your next seminar here is in February, is that right?
February 10th, we have our Level 1 class, a full-day class. February 11th, we have our Level 2 class where we look closely at those appellate court decisions. And if people want more information on those, they can just go to lawofselfdefense.com/rally, because the class is being held in Raleigh, North Carolina.
Awesome. And I do know that those classes fill up very quickly, so people should avail themselves of them quickly. And you also offer an online version of this seminar, too, do you not?
We do at lawofselfdefense.com/online. So basically, it's actually a longer version of our live class, our Level 1 live class, because we don't have the time constraints online that we do in a classroom. And again, it's illustrated with specific North Carolina laws. So people go to the online class, and with that, they choose the state-specific module, supplementary module that they want.
Awesome.
So in North Carolina, they could choose North Carolina. If they also have a vacation home in another state, they can get the supplement for that other state.
Awesome. Thank you very much, sir. We appreciate it. We've had Andrew Branca on the law of self-defense. My name is Paul Vallone. You have been listening to Guns, Politics, and Freedom on Wilmington's Big Talker 106.7, WilmingtonBigTalker.com, where each Sunday at 5 p.m., as part of the Sunday Night Political Power Block, we give you the ammunition to better defend your gun rights. I encourage you to check out our state's main gun rights organization, which I direct. It is Grassroots North Carolina, and you can find it at grnc.org. As I recall, your next seminar here is in February, is that right?
February 10th, we have our Level 1 class, a full-day class. February 11th, we have our Level 2 class where we look closely at those appellate court decisions. And if people want more information on those, they can just go to lawselfdefense.com/rally because the class is being held in Raleigh, North Carolina.
Awesome. And I do know that those classes fill up very quickly, so people should avail themselves of them quickly. And you also offer an online version of this seminar, too, do you not?
We do at lawselfdefense.com/online. So basically, it's actually a longer version of our live class, our Level 1 live class, because we don't have the time constraints online that we do in a classroom. And again, it's illustrated with specific North Carolina laws. So people go to the online class, and with that, they choose the state-specific module, supplementary module that they want.
Awesome.
So in North Carolina, they could choose North Carolina. If they also have a vacation home in another state, they can get the supplement for that other state.
Awesome. Thank you very much, sir. We appreciate it. We've had Andrew Branca on the law of self-defense. My name is Paul Vallone. You have been listening to Guns, Politics, and Freedom on Wilmington's Big Talker 106.7, WilmingtonBigTalker.com, where each Sunday at 5 p.m., as part of the Sunday Night Political Power Block, we give you the ammunition to better defend your gun rights. I encourage you to check out our state's main gun rights organization, which I direct. It is Grassroots North Carolina, and you can find it at grnc.org. Main gun rights organization, which I direct. It is Grassroots North Carolina, and you can find it at grnc.org.